Hi, folks. Denise Howell here, and you're about to listen to This Week in Law. Christine Farley is our guest this week, along with Mike Keyes and Emory Roane and me. Google's use of Oracle's APIs is fair use, but is that going to be enough? We're going to talk about what you might want to consider wearing to Comic-Con and what not to wear. We're going to talk about why the Slants case is going to be so interesting before the Supreme Court. And Axanar, it looks like, will fly again. All this and more on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell, Emory Roane, and Mike Keyes. Episode 347, recorded May 27th, 2016. There's a Tribble in my tent. This episode of This Week in Law is brought to you by TunnelBear. TunnelBear is the simple privacy app that makes it easy to browse privately and enjoy a more open internet. To learn more and get your free TunnelBear, visit trytunnelbear.com/TWiL. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. Thank you so much for joining us. We're going to have a great show today, very much to discuss, and a great panel to do it with. Joining us from the American University Washington College of Law is Professor Christine Farley, where she teaches intellectual property law, trademark law, international and comparative trademark law, international intellectual property law, design protection law, and art law. Hello, Christine.
Hello. Thanks for having me. I'm excited about this.
I'm excited about this too. It's great to meet you. Great to have you on the show. Also joining us are my two awesome co-hosts. Emory Roane is here. Hi, Emory. How you doing?
Hey, Denise. Hey, chat. Christine, Mike, everyone that's listening. I think we've got a great show. Very excited to be here.
Very excited to have you back. And Mike Keyes. How are you doing, Mike?
Hello, Denise. I'm doing great. Great to be with you and Emory and Christine.
Mike is at the Dorsey firm in Seattle. Emory, how's school going? Are you all done yet?
Oh, not yet. I've got another year to go, but in summer classes. Yeah. It's school year round for me. So I'm in summer classes now, but it's going great. Yeah. Got an internship at the EFF come fall that I am very much looking forward to. So.
Oh, that's fantastic. Are you actually going to go to the Bay Area for that, or are you going to do it remotely?
Oh, definitely going to be there, but just have to figure out how that's going to happen and in what form over the next couple of weeks. But yeah.
Wonderful. Congratulations on that. That's awesome.
Thanks. Yeah, very excited. Appreciate it.
All right. So I bet you guys know where we are going to start the show. We are going to start the show discussing the jury verdict that came in yesterday in Oracle versus Google. Big news, and just in time for us to talk about it on the show. Thank you, jury. Thank you, court, for blessing us in that way and blessing us with such an interesting topic to discuss. The jury came back yesterday after trial in San Francisco, in federal court in San Francisco, in the Oracle versus Google case that has, it was on a brief hiatus. The jury broke for a little while and just came back yesterday with the verdict after hearing all the evidence. And it was a unanimous verdict in favor of Google, upholding the proposition that Google's use of Java APIs, all 37 of them, was fair use. They went through all the fair use factors. They had a very dramatic and interesting trial with several high-profile witnesses and file cabinets, paintings that were supposed to illustrate what fair use is and isn't in usual contexts, all kinds of great, interesting tidbits from the trial. And if you haven't already delved into Sarah Jiang's live tweets from the trial, some of which have been compiled into Storify collections by her, they give you a real flavor of what the courtroom must have been like, and certainly her unique take on what she was seeing play out in front of her in the courtroom. So that's definitely worth a look if you haven't already been there, in addition to the copious other coverage of the case that's been going on for the last couple of weeks and in the wake of the verdict yesterday. So I guess I'll just go around. First of all, maybe we'll set the stage for this for people who haven't been following this case from its infancy. It's been going on for quite some time now. This is the second trial before this same judge in San Francisco. In the first trial, Oracle floated a bunch of other theories that are no longer in the case. Their copyright was in the case at that point, and there was a determination by the jury in that first trial that infringement happened. However, the jury in the first trial deadlocked on the issue of fair use, which is what they just tried and concluded yesterday. So then we had the Federal Circuit get involved. Actually, before the Federal Circuit got involved, the trial judge himself got involved and granted a routinely filed post-trial motion. And I should mention that we will see these kinds of motions get filed yet again, this time by Oracle, to have the judge take a look and see if he's going to let the jury's verdict stand. For various reasons, they may argue that that shouldn't happen. And in the first trial, Google actually prevailed on one of those motions and got the trial judge to say, hey, you know what? What we're talking about here, these APIs, they're not actually copyrightable. So this infringement verdict, that means nothing because it shouldn't be infringing as a matter of law. It's not something that infringement can apply to. So that is the issue on which the appellate court got involved, the Federal Circuit Appellate Court, and undid. Said, nope, sorry, we disagree. We think these things are copyrightable. So go back down, go back to trial, because we're going to need to get this fair use issue resolved. Because if this is fair use, then it doesn't matter that infringement took place. Google's in the clear. So that's the trial we just had, and that's the determination the jury just made. So with that all in mind, I want to go around and ask each of our panelists their impressions of the trial and their impressions of presenting a fair use defense in a circumstance like this to a jury. Let's start with you, Christine. What was your take on all this?
I think this decision is being hailed as a victory. But there are a couple of problems. First of all, this could be appealed again to the Court of Appeals for the Federal Circuit. And that was the court that you mentioned already. Denise had overruled the district court's finding that the APIs were not copyrightable. So this could again go back to that court. And I think that it will. I think that Oracle will probably appeal. And then the second problem is that although this decision is being lauded as a victory for developers, it's not as good as a finding that APIs are not copyrightable. So this is a finding that in the specific instance, what Google did in developing its Android operating system was a fair use. And of course, Google had all of its resources and all of its lawyers to do a 2-week trial, and it was extremely well done. And so that jury could find fair use. That doesn't mean that every other developer will be that successful in a claim of fair use. And because of the unpredictability of a fair use determination, there could be a chilling effect. So it may be that developers won't see the green light in the way that we're talking about right now, because of the fair use finding that they would have seen had it been a finding of no copyright protection for APIs.
That's right. You put that so well, Christine. It precisely encapsulates what's going on here. And as we often reiterate on the show, fair use is nothing if not a crapshoot. The factors are complicated. They're difficult for juries and courts to understand and apply. They shift in each case. In looking at all the evidence that came in this case, there was no way to ballpark which way the jury was going to go on that fair use issue. It could easily have gone either way. So it is no guarantee that others similarly situated similarly situated are going to get the same kind of outcome on any kind of consistent basis. And also, just to procedurally note, the question that actually, as this whole procedural history of the case was winding along, Google asked the Supreme Court to get involved on this copyrightability question. The Supreme Court declined. It'll have another shot at that once Oracle does, and I'm pretty sure they will too, Christine, take this up on appeal one more time. Once we've had the appellate court's final, the appellate court won't revisit its determination on copyrightability. But once the appellate court has had its final say, that's when any party who wants to take issue with any part of that determination can and probably will ask the Supreme Court to get involved and take up that copyright issue. There's no guarantee the Supreme Court will, but it's an interesting and important issue. And if the Supreme Court took it up, then we could get perhaps more certainty and give parties something other than this wishy-washy, totally unpredictable fair use opportunity, which is what they've got now.
That's right.
Yeah. So, Mike, what's your take?
I think this is a hugely important decision. I think it's hard to overstate the significance of it. Something that just struck me with Professor Farley's comment is my understanding is the first go around, the case was appealed to the federal circuit because there were patent claims involved, and of course under the federal statutes, the federal circuit would have jurisdiction over any decision involving patents. Now that the patent claim is no longer in the case, Professor Farley, would this go to the Ninth Circuit instead of the federal circuit, or is it going back to the federal circuit that heard the appeal the first time?
I think it's going back to the federal circuit. It's a good question. I hadn't really thought about that. It's interesting that we think of the federal circuit as being expert in intellectual property law. Of course, it's much more expert in patent law than in any other areas of intellectual property law. And in copyright law, it's the least expert. I think certainly the Ninth Circuit, the Second Circuit, the Seventh Circuit are much more expert in copyright law issues. And with regard to fair use issues in particular, that's been an area of law that has developed such nuances and sophistication as we saw in the Google Books case that was just decided last year in the Second Circuit. So I think it will go to the federal circuit. I don't think they're the best circuit to hear such an important case. But the silver lining in that is that initial ruling on API being copyrightable is only the law of the federal circuit, right? It's not the law of the Ninth Circuit, the Second Circuit, the Seventh Circuit, other circuits. So, that's one bad decision, and it's just one.
Someone in RFC, Rev. Dan O'Metal, is proposing a solution to all of these legal maneuverings and where it goes next and whether the Supreme Court gets involved and how it's all resolved. He thinks that Google should just buy Oracle at this time without too much FTC or SEC fuzz. It's an interesting idea.
Well, there's an interesting fact here.
Yes, so, please tell.
Oracle, they sought damages of $9 million, but they bought Sun Microsystems for $7.4 billion.
Yes, thank you.
So, yeah, the numbers seem out of whack.
They do. All right, Emory, to you. Let's talk about file cabinets and paintings and some of the other fun aspects of this case.
Yeah, I got to go last, but Professor Farley essentially encapsulated everything I could have said about this. My takeaway was that, great for Google, great for the idea for open source software developers, but not nearly as great as it could be. In a lot of ways, the real problem goes back to the idea that APIs should not be copyrightable. At least in my opinion, I think that Professor Farley would agree that, this is a hugely expensive case that went on for years. It was very, very, like you said, it was absolutely unpredictable about which way the jury would go. Because frankly, I think that applying a fair use argument to APIs I'm not sure. I can see convincing arguments on both sides that, for example, using API calls isn't necessarily a transformative use, that you're using the software as exactly as it was intended, and that if there was a previous market for these for their licensed APIs, then I can see the fourth factor not really going in Google's favor either. I think that's the real problem, is that fair use is such a complicated analysis and so unpredictable in case by case. It goes back down to, is fair use the way that we want to be defending APIs? I would say that sounds like it sets a bad precedent to me. The idea that any small team of open source developers are going to have to potentially go the same route that Google is going is alarming. What I would have liked to have seen out of this was a little more clarity in the fair use doctrine. And I don't think that was really given here. And I think that it's, the same sort of similar reaction to the Axonar Paramount thing we'll discuss later. It's like, yes, this is great on the one hand, but from the fair use side, it doesn't really leave us in any more sturdy ground than we were before.
Yeah, and you're picking up on one of the more flashy moments of trial, a theme that Oracle seems to have hit on throughout the trial, is this ill-fitting nature of the fair use doctrine to this particular set of facts, and how we're used to fair use applying to what we think of more conventionally as creative works. Now, Google, of course, put witnesses on the stand that talked about the creative nature of the code in general, both from their side of the dispute and from the Oracle side. But be that as it may, and Oracle at one point held up a canvas with bits of code across it, saying, now, if you did something like this, if you hung it on a wall.
Yeah, tired argument is tired, though.
But that's not what Google did here.
So that's a very limited understanding of fair use. If that's all you can do is put it in a frame.
Yeah.
Right. Exactly. But, again, I guess we're getting into the jury had a couple of challenges here. Number one, fair use is not the easiest water to navigate. Number two, as Sarah John kept saying during trial and in her coverage of the trial, she thought she understood what APIs were, but now she, at one point she said, I'm totally at sea. I don't know what's an API and how is the jury supposed to suss this all out. So they definitely had their hands full there, but that's part of what our jury system is designed to do, right? I mean, the judge in this case taught himself Java at one point so he could get a better handle on the case. I don't think the jury would even be allowed to do something like that. But it's the lawyer's job in the case to try and make it comprehensible, try and come up with metaphors and analogies and descriptions, and have expert witnesses on the stand that help you put things in understandable terms so that the jury can get their head around it and make a determination. One way they tried to do that in this case, Google's lawyers, and I guess they did this in the first trial too, was with a great big file cabinet that came out in opening statement and I think was lingering around the courtroom until the very end, one way or another.
Props are important.
Yes, that was their metaphor for understanding what went on here. And again, this is something Sarah Jong wrote about at Motherboard. What is the file cabinet? How is it supposed to be an API? Is it supposed to be, what's it illustrating exactly? Because at the top of it, it was labeled java.lang, and then the top drawer was labeled math. And then Sarah would reach into the drawer and pull out a file folder and show the file folder. And she actually did come up. Let me see if I can find her quote here. I know that we're looking at it on the screen. She did come up with what she thought was their point, and it did make some sense. But I wonder if the jury ever got it. Let me, there it is. Let me read you what she finally concluded. No, that's not it. Anyway, while I find that, Mike, tell me what you think about using things like file cabinets in cases like this to get the jury to understand.
Oh, I think it can be very effective. I think props, as Emory had just mentioned, are very important. It kind of puts it into context, makes it much more concrete for juries to understand. So I think it made a lot of sense. The fundamental question, though, it seems to me in this case is, one, I think the point was already well made today, is that, this really isn't, jury trials don't set precedent. We don't really have that much more clarity in terms of how fair use applies in this context any more today than we did yesterday. We just know that one particularly very successful company was successful in convincing a jury in the Bay Area that fair use applies. We don't have any great clarity here. And the fundamental question I have when it comes to fair use is whether this should ever be a question for the jury to decide to begin with. So we know that you have a right to a jury trial under the Seventh Amendment, and there's a lot of case law that discusses the rights of parties to have a jury trial. But to me, the fair use doctrine, this is something that's a relatively new vestige of the Copyright Act. It came in with the 1976 Act. And so this isn't something that was traditionally tried and dealt with at common law. And as the judge's jury instructions say, this is an equitable rule of reason. And so the jury instructions kind of bear that out. At one point in the jury instructions, it says, no generally accepted definition is possible. And he's speaking of fair use. And each case raising the question must be decided on its own facts. And the court later in the jury instruction says, you may consider any additional circumstances and evidence, pro or con, that in your judgment bear upon the ultimate purpose of the Copyright Act, including protection of authors. So, when you read the jury instructions as a whole, I think it makes it very clear that this is an equitable rule, and it's very fishy just by its very nature. I'm not sure we should be in the business of having jurors decide equitable questions as far as fair use is concerned. So on appeal, I would imagine that's got to be one of the issues that's going to come up. Is this something that the jury should even have been tasked with deciding to begin with?
Yeah, and that you raise a good point there, Mike. And that could be a huge, if the court decides to go your way and say, no, we're not going to have jury trials on fair use, or maybe juries' roles in fair use cases should be limited only to deciding, whether certain facts were present or not, and then you let the court make the equitable judgments. That would be a huge shift in the law as it sits right now, right, Christine?
Yeah, I'm not an expert on juries, and I think everything I know about how juries operate would lead me to believe that they didn't think about these issues exactly as a group of 10 lawyers would have thought about it. You never know in a 2-week trial what the jury is going to seize upon, what is going to kind of animate them. They deliberated for 3 days in this case, so they were really thinking about it. They came up with a unanimous verdict, but there are definitely clear-cut factual questions involved in the fair use factor test, but it's just a factor test. So how anybody arrives at a determination after weighing 4 factors is a mystery. And in this particular case, as has already been noted, trying to think about using declaratory code in a transformative way and whether that's a fair use, I think, it would have been a challenge for any of us to consider. It was a long, dense, complicated trial. On the other hand, those jurors had a roster of characters come in that, I would have liked to be on that jury. That sounded like a lot of fun to hear all these stories. Some of the things that came out in the trial, though, I think could have persuaded a jury that ultimately there was fairness. So if they had a much sloppier approach to fair use, to say, ultimately, I just have to determine whether what Google did was fair. I think there are a lot of there was a lot of testimony, a lot of facts that would have, even with a limited understanding of what APIs were or what transformative use was, would have led them to believe that, we're talking about, Java open source, these particular industry players thought it was okay. There seemed to be some understanding. There seemed to be some industry practice. And I think that's why maybe Oracle was pushing this case theory of they took a shortcut. They were trying to, jump ahead. This was almost like a unfair trade practice in the way they took a shortcut. So they were also, Oracle, I think, was also pushing a more, everyday notion of fairness in trying to wrap your head around, this test.
Right. And Sarah Zhang, from her sitting in the courtroom, came up with a great pithy summary of what was going on at trial. Oracle casts Google as thieves. Google casts Oracle as sore losers. And the jury, I think that theme probably went throughout, and the jury finally decided they believed Google's take on it more than Oracle's. So the file cabinet, as Sarah finally decided, and I think she's probably right. I mean, it sounds reasonable. After conferring with others, I have determined that Van Est means to explain that the system of filing, the labels on the folders and the drawers, is the API, and that he waved around some empty folders to illustrate how Google wrote its own implementing code to fill the folders with, rather than stealing Oracle's intellectual property. So the filing system, perhaps, is what he was going after. Whatever he was going after, it seems to have made an impression. The jury definitely went their way. One sad little note about this trial and the evidence that came in. There are a couple of things to note from the evidence. Number one is much of Oracle's evidence had to do with internal emails from Google engineers talking about copyright and licenses and saying things that they had no business saying because they're not lawyers and didn't understand, whether there might be fair use or what they were talking about at all. So there was a lot for Google to explain away that its people were saying internally that really shouldn't have any bearing on the case, but that did because it sounded bad. If they're saying things like scrub Java from the discussions and we're going to need a license here, things along those lines. Good cautionary tale for helping your people within your company try not to speculate about legal issues, particularly in writing. Although, the case went Google's way in spite of all that. The other thing that I thought was a sad little artifact of this case, the dispute in general, is Jonathan Schwartz, former CEO of Oracle, before it was Oracle, Sun, was the first CEO blogger ever. And I remember way back in the early days of blogging how great that was, and what a wonderful job he was doing, and how it really illustrated to people how corporations could communicate with the public in a very different way than we were used to seeing them communicate with the public, through press releases and everything vetted through PR. Well, it came back to bite Oracle a bit. There was evidence of one of his blog posts where he was congratulating Google on Android and what a great addition it was to the Java ecosystem, and just being a good guy and sort of jumping into the congratulatory fray, I guess, that surrounded Android. But not only did Oracle delete that particular blog post from its archive of blog posts, but it deleted everything that he had ever posted. So that whole legacy of the first CEO blogger is gone unless you go to the Internet Archives now. So I thought that
just
was
to highlight what a awesome project the Internet Archive is. So
yeah. A little bit heartbreaking, trying to rewrite history. And of course you can't, that doesn't stop the post from existing and coming into evidence. I don't think it's a great idea to try and scrub things like that. I think it just makes you look bad.
Speaking of scrubbing, going back to the transformative discussion of of Google's use of the APIs, I was wondering how everyone else felt about this, because I mean, as far as I could tell, the transformation that they did was, besides applying it to Android, to build Android, specifically, they went through and scrubbed references of Java from any of the code for, I think they were worried about trademark reasons. My question here is, I mean, here we are today. APIs are copyrightable, but this application is apparently fair use. Where do you think that leaves us on the actual, what is not a fair use of an API is what I'm saying, because it feels like anytime you're using an API and building another project from it, if you're going by this case, it would tend to be or seem to be fair use, which I don't think is necessarily, again, it's just not exactly the clarity that I had hoped to see. Professor Farley?
Yeah.
Can you think of an example?
Sorry, I didn't want to jump in.
Oh, that's okay. No, I wanted you to jump in. Can you think of an example of a use that would not be fair use under the standards that, based on the evidence we saw here?
Well, I don't know if it's so much of an example as a story that you tell. So, Denise, you've already mentioned all of these pieces of evidence and the documents that came out. Unfortunately, with intellectual property cases, anytime you have a lot of that kind of, destroying of evidence or, talk by Google employees, we certainly are violating a copyright here. We have to pretend we're not, or, get a license. These kind of background stories, although not often legally relevant, make it seem as if the defendant is acting in bad faith, and it's very hard to find fair use by a jury or even by a judge when you've got this background story of bad faith use. So I don't know that it's a technical example that would make it turn the other way so much as just a different set of facts, a different case, a different jury, a different set of lawyers, a different bag of resources. But I think what's happened here is a lot of people see this decision on fair use as being a work around the Federal Circuit's copyrightability ruling, right? So, okay, you have copyright in API, but that copyright is really thin and almost non-existent, right? So long as people are using API in the way that Google did and the way that it works, that would be a fair use. So I don't know what kind of use wouldn't be a fair use under that way of thinking. So in a way, you get to the same result, and it's a totally different ruling. It's a totally different issue, but it's kind of the flip side of the coin. It really is also arguing that there's just not much to protect in an API, right? If you're using it in this functional manner that it was meant to be used, then it's a fair use.
Zay, do you think that we will see a Supreme Court decision eventually, or a case come up about the copyrightability of APIs? It sounds like this issue is not at all close to being settled.
Yeah, that's right. I guess am I right that the last Supreme Court fair use case was the Two Live Crew Roy Orbison song? Is that right? Can that be right? So that would be a creative work, and I think it is. I think the Google Books case. There are all these other issues now that transformative use seems to be the way to think about fair use. Maybe we do need a little bit more guidance as to how to do that in these instances of non-creative works.
Yeah,
Go ahead, Mike.
It seems to me that to the extent that the case doesn't settle, assuming that the jury's verdict stands and that there's not a settlement, it seems to me that this could very well be a case that wends its way all the way up to the Supreme Court for exactly the reasons Professor Farley just mentioned. Interestingly enough, as I think we talked about on the show a few weeks ago, the Supreme Court was asked to look at the Second Circuit decision in the Google Books case and actually declined to review that case. So this may present another opportunity for the court to look at fair use in the context of computer programs.
And getting back to your point, Emory, on what sort of case could have a different outcome involving APIs, and Professor Farley's point about maybe the jury didn't understand, it's not unreasonable to think that maybe the jury didn't have all of the nuances of the fair use doctrine completely down pat, but was more looking at it in a more general sense of, is this fair or not? Is this the right outcome or not? That the whole aspect of kind of a bait and switch in this case, where Sun was behaving in one way, Oracle came in and had sort of a whole philosophy shift and decided, gee, golly, no, this isn't as open as we might have led you to believe. And actually, you owe us billions of dollars in damages. I think that could definitely change an outcome if there wasn't, sort of a doctrinal shift in the approach of the company that wrote the APIs. So any final thoughts before we move on? Such a fun case to watch and continue to watch. I guess maybe we should talk just a little bit further about what I touched on at the beginning, what we can expect to see immediately next, now that the jury verdict has come in. There will be a flurry of challenges at the trial court to what has just happened. And the court will have the opportunity, though I would be surprised to see it take that opportunity, to undo the jury verdict, to say there's some reason why it shouldn't stand as it is. And then we'll see an appeal. Anything else anybody else wants to add, Mike?
I think that's right. I think we're going to see a motion by Oracle for a new trial and to set aside the jury's verdict for any number of reasons. I'm sure that there were all sorts of pretrial objections that were made. My understanding is that a lot of evidence wasn't considered by the court or wasn't allowed to be shown to the jury because recall that the case was bifurcated. There was no evidence considered in terms of damage. The only issue that the court or that the jury was asked to consider is whether this is a fair use. And so the court tailored the type of evidence that was going to be allowed at that point. So I'm sure Oracle is going to renew many of its objections, to the extent it objected to the jury instructions, which I'm sure it must have in several respects. I bet that's going to all come back, and we'll see what the judge does with everything. And then assuming that the verdict stays intact, there will obviously be an appeal to it's either the Federal Circuit or the Ninth Circuit.
Yeah, and I think it'll be really interesting. Again. Yeah, it'll be interesting to see if the parties get into an argument about the appropriate venue for that appeal. Emory, any final thoughts?
No, I don't have anything to add.
Okay, Christine?
Nope, I'm good.
My final note on the case is I thought it was kind of funny last night. I was looking at Kecker and Van Est's website. They're the trial lawyers who represented Google. Robert Van Est was the lawyer who gave their summation and opening and very big role at trial. Looking at his biography, the law firm hasn't had time yet to update it to reflect what has just happened. So the latest news story about him is something back in February, and their summary, they do have a summary of the Oracle versus Google litigation that is already glowing in terms, just casting it in the best light possible for the work that they've done on the case. It might be fun to read you a bit of it just for that reason, because it's only going to get more glowing after this, right? That they've won this fair use verdict. They say, we represented Google in a high stakes patent and copyright war brought by Oracle with billions of dollars at stake. Oracle, which bought the Java programming language by acquiring Sun Microsystems in January 2010, alleged that Google's Android mobile technology infringed Oracle's Java patents and copyrights. An expert for Oracle estimated Google owed Oracle up to $6 billion in damages for infringement. I guess that went up. Our team defended Google against all the patent and copyright claims and also argued that the damage estimates were wildly inflated. Following repeated rounds of motions and briefing, the judge dismissed the bulk of Oracle's copyright claims. And at trial, the jury rendered a unanimous verdict rejecting all claims of patent infringement. Although the jury decided that Google infringed an Oracle copyright on 9 out of millions of lines of source code, the case is considered a sweeping victory for Google with zero damages. So that's only going to get more flowery in the aftermath of this. What were you going to say, Mike?
I was going to say one last thing regarding the evidence that was considered by the jury as far as the license issue is concerned. There was lots of internal emails that appeared to show that at least some of the engineers thought that a license to Java was necessary. Mm-hmm. I think the jury instructions handed Google a pretty significant favor and noted that. I'm quoting here. You've heard evidence concerning the possibility of Google seeking a license from Oracle. ... Under the law, if the accused use is otherwise fair, then no permission or license need be sought or granted. So, I think in that way, maybe the jury instructions gave the jury the impression that, look, to the extent there was all these discussions internally at Google, it really doesn't matter, because if it's fair use, it's fair no matter what the engineers are saying. Mm-hmm. And if you counterbalance that against what the emails, the congratulatory emails, or whatever the evidence was regarding the former CEO at Oracle, people are, when they're considering that and sizing that up, they may think, look, on the one hand, Google didn't need to seek a license. On the other hand, you've got the CEO at Oracle that seems to be congratulating Google, and then only after the fact are we faced with a situation where Google gets sued. So maybe one of those issues where the jury looked at the evidence and kind of sized it up and thought, well, look, it seems unfair to now punish Google based on these internal emails, based on these instructions. And also we've got this statement from the CEO at Oracle that he seemed pleased with what was going on. So,
and keep in mind that has nothing to do with the fair use analysis. That's the problem with this. If this was decided by the jury on they felt a little fishier. I didn't think, it was a little sloppy, which I agree with both of you that does seem to be the angle that Oracle's attorneys were making. Well, that's not a four-step. That's not a four-prong analysis. That's just, it feels iffy.
Yeah.
Right. Well, and of course, that's the problem with a multi-factor test, right? It's not 4 prongs. You have to find A, B, C, and D. You have to consider A, B, C, and D, and then you have to reach a decision. And we don't give you a lot of guidance as to how to finally come out on that decision.
But it's even a bit squishier than that. You can consider A, B, C, and D, but you can also consider anything else that you find relevant, which, I mean, to give that charge to a jury, it's like, gosh, I mean, then that leaves us incredible amounts of discretion to consider just about anything we want in making this determination, which, I think to me, that's a little troubling here.
Right.
Yeah.
I wonder if you guys know this. I haven't delved too closely at all into the evidence that was presented at the first trial on the point of copyrightability or other defenses to infringement. But it seems to me like implied license could have been argued at some point here based on conduct and statements and everything else. And I wonder if that should be in the mix as this is considered on appeal or not. Does anybody know whether there was that was even an argument in the case?
I don't know.
I don't recall.
No. Yeah. Mm-hmm. I don't know. Seems ripe for it. Yeah, exactly. And again, you can't go revisiting evidence on appeal. That's not what the appeal is for. But it seems like that should have played a role, at least in the first trial. All right. With that in mind, what shall we make our first MCLE passphrase for this episode of This Week in Law? Let's make it something to do with Java. Let's see. Your colleague had a good article headline in writing up the case, Mike. Let's see. More than just coffee. Let's make more than just coffee our first MCLE passphrase for this episode of This Week in Law. We put these phrases into the show in case you are a lawyer or other professional listening to the show and wanting to submit your experience listening to or watching the show as a way of obtaining professional credit in your field, educational credit in your field. We have some information about that at wiki.twit.tv. If you go to the This Week in Law page there, should be helpful if you're a lawyer in one of the 50 United States. More than just coffee. is our first phrase. And we'll put another one in so that if you have to, you can demonstrate that you actually watched or listened to the show. We're also going to take a break and thank our first sponsor for this episode of This Week in Law, and that is TunnelBear. I really encourage folks to check out TunnelBear if you haven't done so yet. It's a simple privacy app. It provides you with a secure and private connection to enjoy a more open internet. And it's cute as a button, I gotta say. It's there's a desktop version and an iOS version. And it's so, both mobile and on your desktop, your work computer, what have you. It lets you bypass all those annoying details that typically come with using a VPN for personal use. You don't need to mess around with any port configurations, DNS, or any other router settings. TunnelBear does all that in the background. It's incredibly easy to use. It's really just a couple of clicks and you're running a VPN. Then while it's going, you can choose a country in the app. You turn TunnelBear on, and your bear, there's a cute little graphic that goes along with this too, literally tunnels, well, figuratively tunnels, your internet connection to a new location and pops out of a little pipe, much like Mario might have popped out in another part of the game. It's quick and easy to get started with TunnelBear, no credit card required. You're able to upgrade that. I think it's like $4 a month on your phone if you want to have unlimited data and unlimited ability to have a VPN connection on your phone, which of course is nice for being able to access the internet as though you were somewhere else. But it's also amazing for keeping your connection secure. They secure your connection with AES 256-bit encryption. You can bypass geo-blocking and hide your location, and your online activity is shielded from third parties, hackers, and other local networks. So if you're someone who travels, needs to jump on unsecured Wi-Fi in order to access the network, this is just basic good hygiene using something like this to make sure that you're secure when you're on those networks. TunnelBear also prevents your internet service provider from monitoring all your online activity if you have it turned on while you're browsing. And you can turn it on and off very easily. You don't have to run it all the time. But it's really, and if you're trying to conserve data, I guess that's why you would turn it off. But if you have one of their unlimited accounts that you're actually paying for, you never have to turn it off. And it doesn't seem to degrade your performance at all by running it. You can tunnel to 20 different countries and use the internet as if you're in that other country. You can get your free TunnelBear now by going to trytunnelbear.com/TWiL. It's a simple privacy app for mobile and desktop browsing. Really want you to visit it, try it out, enjoy their very cute graphics, and the fact that it is so quick and easy. Trytunnelbear.com/TWiL. Thank you so much, TunnelBear, for your support of This Week in Law. All right, we have one other copyright story, and then we're going to move into some other copyright stories, but they're with a more entertainment flair in a moment. But before we move on to there, a bit of an update from Mike's firm's blog for anyone who's gearing up to attend Comic-Con this summer. They've got a post there on Comic-Con costumes and copyright concerns. Great post letting you know what you should and shouldn't do in the way of cobbling together your cosplay or other fan costume for Comic-Con. Mike, you want to give us the rundown there?
Sure. This was written by a colleague of mine at Dorsey and Whitney, Jake Holt, and essentially what he's talking about here are these summer festivals involving comic book characters and how one needs to be keeping in mind that the issue of copyrightability with respect to costumes and uniforms and those sorts of things are currently in play at the Supreme Court. So I thought it was a fun post and one that he wanted to find a way to incorporate something about the start a case. So kudos to Jake on doing that.
Yeah, it is a good read. Wonderfully written and useful. Some good takeaways from it are that you might not be completely in the clear copyright law wise if you cobble together your own homemade costume and go to one of these things. You're certainly going to be more insulated doing something like that than you are if you're putting together costumes and props and things and trying to build a business on that for people who attend these events. If you're doing that without seeking permission or paying license fees and you're making money, you're just kind of begging for trouble there. What else did I think was interesting? The things that he pulled out as perhaps protectable, Ms. Marvel's iconic lightning bolt, Spider-Man's web patterned suit.
So I have a question on that, actually.
Yeah.
If this is going back to the Star Athletica case, where for our listeners, I think Mike can obviously give a better analysis of it, but I think that it has to do with cheerleaders and the copyrightability specifically of cheerleader uniforms that seem to be very similar. But they're saying that the individual elements of a costume are copyrightable so long as the individual elements meet the minimum level of artistic creativity necessary. I think that's the correct standard, right? So specifically then in the article you mentioned that the specific stripes, chevrons, and zigzags would be copyrightable, but the entire costume would not be. In the context of comic convention and dressing up as comic book characters, your point that your colleague brought up that Miss Marvel's iconic lightning bolt and Spider-Man's web pattern suit should be copyrighted or copyrightable. What about the more, I don't want to say generic superheroes, but let's just say you're, you are cosplaying as someone who is in a movie whose costume was certainly deliberately chosen by the costume designer and the director or whatever, but it might be just, I don't know, Indiana Jones's outfit, for example, a hat and a jacket and pants. Like how do you, I'm going to throw that out there at that point, because that's where I am right now.
Yes, and Christine, yes, you pay attention to these sorts of things as well. Can you give us your take?
Yeah. So the test is actually a little bit more difficult than you described, Emory. So a useful article can't be protected by copyright, but some design aspects of that useful article can. So I noticed you're sitting in front of a curtain panel that has paisley design on it. So the curtain panel isn't copyrightable because it's a useful article, but the paisley designs, which are separable from that article, are copyrightable. So there's two ways that it can be separable. It could be physically separable. If you have a statue, which is the base of a lamp, you could take the statue away and it would still be a statue, protectable by copyright. Or if you could conceptually separate the design aspects from the useful article, then they could be protected. You're right. They also have to meet a minimal level of originality and creativity to be copyrightable. But the real issue is not that. The real issue is, are they separable? So it's a question that's going to the Supreme Court about whether those chevrons and stripes are protectable under copyright or not. And so I think there are lots of really interesting issues in these costumes for superheroes. One is, it's not just clothing. These things, might be protectable because there are separable design aspects of what would otherwise be clothing, but they're also protectable probably as characters. So there's, copyright protection for characters. So, when Harry Potter was, still is, a huge trend, can a company sell some kind of a robe and tie and broken glasses and wand? How much of that are generic features and how much of that are, copying the character? So those are aspects as well. So I think it's just a mess. And I agree with the blog post. These people who are doing it for fun on their own, not for profit, are not going to have any trouble. But how far you can copy these things is certainly an open question.
Right. And it always comes up around Halloween too, not just Comic-Con time. what sort of costumes are out there for sale. I've certainly seen plenty of robes and wands and broken glasses for sale at Halloween time, and mused about whether they were licensed or not.
And, it's these kind of fan projects that are why we need this kind of, or one of the reasons why we need more clarification and fair use. Because whether we're talking about this or the Axanar case, like, fan projects are great. It's 2016. I think that the general acknowledgement is that fan projects are not only something that the fans are interested in doing, but that certain segments of the fans can make a living doing. And it seems like there should be some way to provide them the security and clarity that they can continue doing what they're doing. Or no, definitely that they should need to stop. But up in the air.
Right. Friend of the show, former guest on the show, Doug Hanchard, sent me a link over the week of a good example of this. It's not a costume, but just to throw it into the mix, let's see if we can get the tent, the Star Trek shuttlecraft tent. This was a homemade passion project. It is not for sale.
Not with that attitude.
But isn't that just the most awesome tent idea? So he designed and created.
It has a North Face logo on it.
Does it have? Oh, you're right. At the bottom, it does. I don't know why.
Maybe the existing tent was North Face and it's just been screen printed or something.
That could be bad for North Face. Not affiliated with this tent, but this is just a bit of awesomeness I wanted to show you guys, and it plays into, clearly there are copyrightable elements here to this tent that could be problematic if you were selling it commercially, but to put it together, to come after someone who was making this just as a home passion project would certainly not be a popular thing on the part of the studios, which is a perfect transition to our next segment of the show, talking about Hollywood music and entertainment. Axanar, folks. Axanar is going to get made. It certainly looks that way. We have great indications from the recent events surrounding Star Trek Beyond, the next authorized movie in the Star Trek universe of things, where we learned from J.J. Abrams and Justin Lin that Lin in particular was angry with Paramount for having pursued this action against the Axanar folks, thought it was just sending the wrong message, that there's no reason to prevent these things from being made, and lobbied hard to get the suit dropped. And apparently we're told that they have been successful. Now, none of the procedural stuff has happened yet, so fingers crossed that this news is going to get carried out by the legal teams. But what we're told is that Justin Lin was outraged. I'm quoting now from the Wired coverage, and I think from J.J. Abrams' comments on this. We started talking about it and realized this was not an appropriate way to deal with fans. The fans should be celebrating this thing. Fans of Star Trek are part of this world. So Justin went to the studio and pushed them to stop this lawsuit. And now, within the next few weeks, it will be announced that this is going away and fans will be able to work on their project. And the Axanar folks, of course, were very excited about this. There's also an indication, CBS tweeted that they're working on guidelines for all fan films. And Axanar says, we're anxious to see what those guidelines say and make sure we have a clear idea of what needs to be done to meet those expectations. So hopefully they won't be too restrictive, and Axanar will be able to become a reality. So this is just so fun, having covered the case and the Klingon language aspect of the case. Mm-hmm. Some detail a few episodes ago. Mike, you happy to hear this?
Well, I guess I'm happy for all the Trekkies out there. Yes. Yeah, I think it's a great Well, now we'll see what happens. I mean, we haven't seen the order of dismissal, and who knows what exactly form it'll take and what have you. But yeah, I think that's a great development for them. The one thing I'm slightly disappointed about is that we still don't have, and probably won't have, a definitive ruling from the court on whether the Klingon language is copyrightable or not. So
this is true.
That's one potential bad, unfavorable aspect, because I think we were looking forward to it. And as a matter of fact, I was speaking with a friend of the show, Mark Randazza, at INTA just a couple of days ago about it. So
Great. What was his take? Did you guys talk about the indications that the case will be dismissed?
We really didn't. We were just musing a little bit about the case itself when I went to the Meet the Bloggers party.
Fun.
So yeah, we had a great time and had a good laugh about the case and about his brief, and a good time was had by all.
And you got to go. And you got to bowl. Did you go bowling?
Actually, I didn't bowl. I went to the after party.
Okay.
These trademark conventions sound like a lot of fun. I gotta say,
They're
way
the
more fun than I expected.
I know. We want to pick your brain on both Christine and Mike went to the International Trademark Association convention. When was it? Last week?
Yep. Just got back yesterday.
So we're going to get your
this week.
further reports on that before the end of the show.
We were there with 9,998 other trademark lawyers, so it was very well attended this year.
So they were just missing me and Denise, and would have been a round number. Oh well, next year. Sorry, guys.
Yes. No, Mike emailed me and asked me if I was going, and I said, I'm not really a trademark lawyer, so now that doesn't quite fit for me. But it sounds like with yeah, absolutely. Well, I'm more on the copyright side, but sounds fun. Who's to miss a good outing? Emory, any thoughts on Axanar going forward?
Yeah, I got some thoughts. I'm, very happy that Axanar is going to be made first off. Obviously, that's, great. I'm going to echo the same thing I've been saying all day, and obviously just because I've been thinking about all this in relation to the Google Oracle and Axanar all at the same time. But, it is a real shame that fair use isn't treated more as a right that creators have, that this is a right to make a fair use. This is sort of the way that this is being framed, is that Paramount is saying, okay, we're not going to sue you, but we're going to release community guidelines. I am holding off on celebrating until I see those guidelines, because I don't necessarily know if that's the way that I would like this issue to be framed moving forward. It'd be great if like Pie in the Sky Goal would have had Axanar go to trial and be said to be fair use, and just lay a clear precedent for other people that are wanting to make quality fan films. Because what this is Axanar is very lucky in that they have gotten a lot of publicity, and that happenstance at a Star Trek fan event. That's what was going on, a fan event where J.J. Abrams decided that this isn't a good way of treating the fans. We need to work with our fans more directly, and we're going to make this go away. What it means that when it's going away, what these guidelines are going to be, it doesn't. I can see this having a chilling effect, because if you're a small group of filmmakers that are wanting to make a fan film, you are not going to want to run the risk of getting to the point of where Axanar is right now, and not be comfortable with the fact that you can't make a strong fair use argument. You're going to have to hope that you can come to the table with the owners of the copyright. So,
yeah,
great, Axanar. I'm looking forward to seeing it.
I think you've touched one of the fundamental problems that some folks have with the whole fair use analysis to begin with, and that's you're never going to know if it's a fair use until a court rules as such, or a jury vindicates your argument, or you settle the case. So, unfortunately, depending on your perspective, I suppose, that's how the Copyright Act is set up. It's really effectively an affirmative defense that you have to establish. So I'm not sure that we're going to see any changes with respect to that issue, unless there's some sort of congressional enactment that amends it to make it more of a right, as opposed to proving that you've prevailed as a defense.
Yeah.
Right.
Yeah. I mean,
and as,
right there
as you're talking through this, all I can think about is that fair use needs a Peter Thiel, needs someone who will come in and help out the Axonars of the world and others who have a great legal position that, if they carry it through, would lead to some good law and help them bankroll. Because, for Axonar, this is a huge win. They don't want to litigate. They want to make a film.
Exactly.
Although, so Axonar filed a counterclaim on Monday. So this statement was made by Paramount on Friday, and then on Monday, Axonar filed a counterclaim for declaratory,
right?
That
which again
they
probably just filed because there was a court deadline saying that they had to file by that time, and the lawsuit hasn't been dropped yet.
Some blogs that suggest that CBS may not drop the suit, that a suit may continue between Axonar and CBS. Paramount may be out. So we could have a ruling on Klingon being copyrightable. We could have a ruling on fair use. You both could be made happy. I think it's, as I understand, the film is set 21 years before the first episode. So these always raise really interesting copyright issues in fan fiction when it goes so beyond, the basic character development, the basic plot scenes. I think there are some really, before we even get to fair use, there may be some really interesting issues about what in this film would be copyrightable, because they can't be referring back to things that have already existed if it's set in advance. So, I'm sure there's great arguments for things that are copyrightable in the film, but they're interesting at least.
Yeah, and that's my fair use is such a complicated issue, but at the same time, remix culture is so huge and fan fiction is so huge that it feels like, yes, fair use wasn't in the Copyright Act until 1976, but I would think that, I wish I'd done my research beforehand to have the cases on hand, but we definitely had common law instances of fair use before the 1976 incorporation. And it's changing
more
it
than
so
100
that there
years,
was
more than 100 years before 76.
Right. So, where everyone knows where I'm on this. I'd like some more clarity to provide fan fiction and fan films.
You raised the question about the fan guidelines. So as I understand it, this film has been in production since 2010. So over 6 years, you'd think that, people could have worked with the fan base on this project to figure out, where the limits were for them to go.
Right.
And it's a shame. It's a shame they didn't.
Yeah.
There is potentially a lot of work that they'll have to rework in order to comply with those guidelines. Monkey Island, Emory, you want to tell us about this?
I'm surprised it ended up on the show notes, to be honest. This was sort of personal tweeting, but the Monkey Island, Secret of Monkey Island is 1 and 2 were some classic adventure games from the early 90s that have since been when they were made, they were owned by LucasArts, but LucasArts, when it got bought out by Disney, meant that the rights to those games went to Disney. What you're seeing in recent years is a really interesting, awesome resurgence of sort of HD-ifying old video games, or almost like digital archiving, rejuvenating games that have since become so old that they don't even run on current systems, where you can't buy them on current markets. So, for example, Double Fine and Tim Schafer, who actually worked with Ron Gilbert on Secret of Monkey Island, in recent years has re-released Grim Fandango, and this year they just re-released Day of the Tentacle, which is great. And basically, Ron Gilbert has been saying for years that he would like, Disney is not really in the video game business. Last week, they shut down the last their most recent entry into the industry. Disney Infinity was a video game with little toys, and they just shut that down. So right now it looks like Disney is no longer making video games. So Ron reached out and hoped that they would sell him the rights to the game. So my fingers are crossed.
I hope they do. Free the monkeys. That would be fun. Shall we talk about Oculus and DRM? I don't really have my arms around this story very well, but in a nutshell, I think I'm not butchering it, that There are some Oculus games that there used to be a workaround to make use on other headsets. Oculus has redesigned things such that the workaround doesn't work anymore. And now there's beginning to be this arms race of interoperability in the VR headset realm, what will play on what headset. Kind of harkens back to the API and interoperability issues of the Oracle versus Google case, although
I think it's actually very similar.
Yeah, DRM's a little bit different, but say in the same neighborhood of issues at any rate. This is, I guess I just bring it up on the show today because there are some skirmishes going on around this. Of course, VR is the thing everyone wants to talk about these days and is exploding in popularity. And whether or not the creative works that make VR fun and meaningful interoperate on different headsets is going to be a big deal. So something to watch. Anybody want to add anything to this?
It seems.
Go ahead, Professor. Sorry.
It seems to me what I take from this story is that Oculus hasn't figured out its business model yet. There were some statements early on about, how they didn't want to manage users' headset purchasing decision, but they wanted to make things available. And their recent action of changing this patch makes it seem like they want to have more of the business model of the razors. You get a cheap razor and you make the money with the blades. So they're trying to make the money with the headsets and not with the software. And I think the difference here, as you kind of just alluded to already, Denise, is when it comes to DRM, copyright owners have very strong protections through the Digital Millennium Copyright Act. So it seems maybe like, I don't know so much about this, but it seems maybe like this might be a clear violation of disabling the DRM.
Yeah. So a little bit of background on this. Oculus, way back in the Kickstarter days, was sort of founded by Palmer Luckey, first of all. And Palmer Luckey is this young kid. He's 22 years old now. And at the Kickstarter in 2012, was very much into the open source movement and had said that during the Kickstarter, they had said that versions of the Oculus Rift would be open sourced. There was that was part of the ethos and the community behind Oculus Rift's sort of meteoric rise over the past couple of years. And then there was the Facebook buyout. And so this is the most recent in a long line of shoes falling since the Facebook buyout, where there seems to be sort of disparities between the original intentions of Palmer Luckey and the current corporate necessities of Facebook ownership. So, for example, a couple months ago, we were talking about Oculus had made some waves because their EULA had included things like they would be tracking all of your body motions and where you are looking in VR because they can. And people were pushing back then, and they were saying that was just, this is Facebookifying Oculus. Well, this is sort of the same thing. Palmer had said explicitly in no uncertain terms before on Reddit, in direct response to someone asking something about DRM, that, they would have exclusives. They would have exclusive games exclusive to their headset, but it would only be exclusive to the marketplace that they have, that you could buy the games on their marketplace, and then they would be platform agnostic. They could run on any headset. And that also is a really big part of the sort of PC gaming community historically, the idea that you could run any game on your hardware. The idea of exclusives was always sort of a console gamer thing. A lot of people are pushing back against the idea that Oculus is bringing exclusive video games into a PC marketplace, where ideally a lot of people think these virtual reality headsets should be treated more like monitors than some kind of console. So what Oculus has done, they originally said they weren't going to have any sort of DRM on their software, and there wasn't any. You could buy software from their marketplace, and they had said that there was technical reasons why the games couldn't be run on their competitors' headsets. And this person came out with an injector, a wrapper called Revive, which effectively let people that owned the competitor's headset to play games that they legally bought on the Oculus marketplace. That support. I mean, obviously, Oculus said that they would never support such a hack. They called it a hack, and they implied that it would be losing, that wouldn't work in the future. And sure enough, in the most recent update, Oculus went out of their way to break that injector. And so there's a little bit of subtlety here in that before, what the injector was doing, it wasn't breaking DRM. It was just, in a lot of ways, treating it like a shortcut. It was wrapping it in an open source driver. What Oculus has done since has instituted DRM. They've created a lock that checks a hardware that is tied to the Oculus Rift itself. So now the software checks to make sure that you have an Oculus Rift, and if you don't have an Oculus Rift, you can't run the software. I mean, in a lot of ways, that sounds very similar, but there are some distinctions there. The idea of instituting a hardware lock rubs a lot of people the wrong way, and I think that they're all reason to. And Professor Farley hit on a great point that, the DMCA affords a lot of protections to copyright owners, and I don't think necessarily that Revive would qualify as one of the exemptions that would allow you to remove their DRM. So it's a evolving battle. Oculus is certainly being very controversial right now.
And would you say, I mean, it kind of seems to me, because they've been around for so long and gotten so much press coverage, would you say they're sort of the big hitter in that arena? There's so many VR headsets available now.
Yeah, I mean, there are two big hitters right now. There's Oculus with the Rift, and because they've been around since 2012 and have had such great publicity and were the only dog in town for so long, they have sort of that Kleenex brand recognition where people just think VR, they think Rift. The other major player is HTC and Valve. Valve is the company that owns Counter-Strike and Team Fortress and Steam. They're the big players in the PC gaming world. And of course, I'm not going to get into it, but yeah, HTC and Valve versus Oculus Rift. And yeah, HTC and Valve are definitely going a different route. They have their EULA says in no uncertain terms that they will not be tracking you, that they will not be using the data for marketing or advertising. They have from the beginning said that games bought on Steam could run on Oculus Rift and Vive. So yeah, it's a lot of people are justifiably upset, I think, because Oculus for such a long time was pitched and has some awesome people behind it, awesome programmers, really great name recognition. John Carmack is part of the team. And for the longest time, they were supposed to be, virtual reality done right. It was going to be open source, and it was just going to open the doors for this incredible new art form. And we're seeing the sort of Facebookification of that dream, which is a little sad.
Yeah, it'll be interesting to see if folks pay attention to those differences, or they even are aware of them, that you're going to get one sort of consumer experience based on the EULAs in terms of service in one universe than you are in the other. And it might make a big difference to people, but I as people jump into the VR arena, I'm skeptical that they're going to even know that this is going on or that it's something they should pay attention to. So tell your friends, pay attention. All right. We alluded to the International Trademark Association meeting and some trademark issues. So let's go there now. I put a bunch of trademark related stories that I thought looked interesting in the rundown. I want to check in with Mike and Christine and get their takes on the meeting they just attended to. And then I just want to let you guys run with whatever of those stories you think are interesting and tell us, expand on anything in the rundown that you think is worth paying attention to for us and our audience here. So Mike, we'll start with you.
Oh, as I mentioned, I was there at INTA. It was held in Orlando this year. There were approximately 10,000, I think a little bit more than 10,000 folks that ultimately attended, a huge gathering of trademark lawyers. And I think, as Professor Farley mentioned, it's not just trademark lawyers, copyright practitioners and patent lawyers and all sorts of folks show up from all over the world. It was a great conference, as it typically is. I wish I could have attended more of the formal sessions, but I was meeting up with colleagues and clients and other folks. So had difficulty attending most of the sessions. I did have an opportunity to present with some other great lawyers, though, on trademark-related damages and some of the latest and greatest issues when it comes to damages in trademark cases, and preliminary injunctions, and so on and so forth. So had a great time. Wasn't sure if there was anything in particular. I'd love to hear from Professor Farley on any of her thoughts on the rundown.
I had a great time. There's great content at the conference, of course. I think it's also really good for lawyers to meet face to face. I understand there are a lot of meetings between brand owners and various intermediaries where they can reach some agreements before having big public fights. So I'm sure that's really useful. Some of the noteworthy topics, I thought, I attended a really terrific session on scandalous and immoral marks that included two judges from the Court of Appeals for the Federal Circuit who decided the In re Tam case about the slants trademark. Mm-hmm. And Judge Moore was one of those judges, and she was the one who authored the majority opinion in that case and was frankly pretty open and honest and willing to share her views about that case and others. There was another session that featured the lawyer for another case which is currently pending before the Federal Circuit Court of Appeals, and that involves the mark FUCT, which had been rejected as being scandalous. But the Patent and Trademark Office submitted a letter brief to the Federal Circuit saying, based on your ruling in the slants case, we don't know that we're able to distinguish between your view that the statute is unconstitutional for scandalous and disparaging marks. We don't seem to find any room for distinction there. So, until the Supreme Court rules on this, we can't apply the statute at all here. So they're suspending all of the cases that may involve disparaging or scandalous marks for the time being. So it's really a very interesting set of issues that has absolutely exploded in the last year and a half. And of course, we're waiting for the Supreme Court to jump in here, and I think that they definitely will. But there are a number of things that could or could not happen. One is the Supreme Court could just look at the slants case. The trademark owner for the Washington Redskins has petitioned the Supreme Court to hear their case along with the slants case, even though the Court of Appeals has not ruled in that case yet. And I think this person who was speaking at INTA with the FUCT case, he could also petition the court to pull that case in as well, even though, again, the Federal Circuit hasn't ruled in the case yet. So that continues to be interesting and was really a lot of the talk at INTA. But I'll tell you about a couple other things. The noteworthy exhibitor, again, was the GTLD.sucks. They managed to grab a lot of attention last year in San Diego, and they were equally provocative this year. They were giving out candy hearts with a brand name .sucks, and they had lots of different brand names. They had candy hearts that said into.sucks and everything else. Awesome. And they were printing T-shirts where you could fill in the blank .sucks. So, if you wanted to say Louis Vuitton .sucks, they would help you make a T-shirt that said that. So that they were there as well. There's some great topics on trademark bullying, which is a topic that I think this community really needs to talk more about, because there are bullies out there, and at the same time, we don't want to paint with a broad brush cases that are legitimate. So there was a good discussion of that. And then finally, another exhibitor, an interesting exhibitor, was a law firm which is specializing in the area of trademark filings in Cuba, which of course is exploding at the moment. People are either rushing down to register their own trademarks in Cuba or rushing down to register somebody else's trademarks in Cuba. And so there was a lot of discussion about that as being something that's new and noteworthy right now in the trademark world.
Right. I saw a news story recently on some local restaurant owner in Cuba who had a restaurant called McDonald's.
Yeah.
That he's had for a long time. And, he does use some golden arches and things. So it's definitely meant to remind people of the U.S. brand and how there was going to be a lot of controversy for other similar businesses in Cuba that have been operating that way and may not be able to for much longer.
Well, I mean, this happens all over the world, of course, and we saw it huge in China, huge in Russia. But in fact, American businesses, even under the embargo, have always been able to register their marks in Cuba, and many have registered their marks in Cuba. Coca-Cola, for instance, is registered in Cuba. So there really shouldn't be the rush that there is right now. And in fact, Cuba has signed all of the trademark treaties that the United States has signed. So I think there are going to be some good protections for trademark owners for anyone who's trying to preempt the rights there.
A couple of follow-up questions for you based on what you reported in for us from INTA. Is a trademark bully roughly equivalent to a patent or copyright troll?
No, there are different concepts.
What's a trademark bully then?
So a trademark bully is someone who has legitimate rights, not somebody who's just acquired a piece of paper saying you have a trademark, but who has a mark that they are using. But nevertheless, they're bringing spurious lawsuits against small mom and pop shops. And they're sending wild cease and desist letters and following up with litigation. And they're basically, scaring away any adversary because people can't afford to litigate or are worried about what kind of trademark rights exist. So they may be asserting a claim of trademark infringement, and they may also be asserting a claim of trademark dilution, which, like we've been saying about fair use, is very difficult to predict. And so if you're, someone who can't afford to hire a trademark attorney and you're in business and you get one of these letters saying, I've got these 10 registrations and, you're violating two different aspects of the Trademark Act, your response may be just to stop using the trademark.
Mm-hmm. Okay, I get it. And then getting back to the scandalous and scurrilous marks, for anyone who's watched our show, listened to our show for a long time, you've heard about the Slants case before. We had Ron Coleman on the show, although he couldn't really talk about the case. He is their lawyer. And this is the, I think they're based in Oregon, Asian band. They're wonderful. They're kind of a punk rock band. We played some of their videos on the show at one point or another. And they called themselves the Slants and attempted to register that trademark. And the Washington Redskins have jumped into the fray and as Christine mentioned, want to get involved in their proceedings too, which the Supreme Court has been asked to step in and weigh in on because of how things have gone both in a court, and then it was the USPTO who asked the Supreme Court to intervene. Is that right, Christine?
The USPTO petition for cert.
Yeah. So I wanted to ask you, because you had an op-ed in the New York Times weighing in on the substance of that dispute. You come down on the side that Simon Tam and the band should not be able to get that registration. Can you tell us why?
Well, actually, no. I think that I come down on the side that the statute is constitutional. The statute should be upheld. I think the decision in that particular case is wrong. I don't think that slant should be one of those words that's barred for being disparaging. I think when it comes to a real racial slur like the Redskins, that meets the test, and the test is a valid test. The distinction that needs to be drawn here is that there's nothing in the Trademark Act that prevents Simon Tam or the Washington Redskins from adopting those words as trademarks. They can adopt them, they can use them, they can print merchandise with those names on it and sell it in commerce. And in fact, they can even go to federal court and they can raise federal claims in federal court against would-be infringers. The distinction is what the act prevents is it prevents the government from issuing a registration in words or symbols that are disparaging or scandalous. So my belief is that is the proper role for the government. We shouldn't be having, the N-word being issued by the government as a registration with a gold seal and the signature of the Commissioner for Trademarks. But the federal courts are open to people who want to use that word. So there's no impact on their speech rights to speak those words. And in fact, the advantages that come with registration are really tools for that trademark owner to prevent the speech of others. So I'm not really concerned about the free speech in the granting of registrations. And this happens all over the world, and in countries that have bills of rights and countries that have constitutionally protected freedom of speech. And I think it's because of that particular distinction. Nobody's out there policing trademarks saying, what you can and cannot say. I love Simon Tam, by the way. He's the sweetest person. And I wish him luck.
Good. Mike, are you on board with that analysis? You think the other trademark protections that exist under law are sufficient and federal registration should be not available for the kinds of marks that Christine described?
Well, let me say first that I thought the op-ed piece was excellent. And I think this is something that reasonable minds can differ on. I tend to come out on the other side of the equation in favor of Simon Tam and the band. And as far as I'm concerned, when you get a federal registration, you are granted substantive rights associated with that. Yes, true, you can get into federal court without a registration. You can sue for unfair competition. You can still enforce your rights vis-a-vis third parties. But a trademark registration is important, and it does provide additional substantive benefits to you as an owner. For example, you have an additional claim for infringement that you can assert. You also have, if you have a valid registration, you have a presumption of validity when you go to federal court that has to be overcome by the other side. If you don't have a registration, you have no such presumption, and you have to affirmatively establish that you own rights in that name. So that's a fairly significant benefit. You can also register your registration with U.S. Customs to prevent importation of counterfeit and other infringing products. So you're far better off, substantively speaking, to have a registration than to not have a registration. And when the difference between something registered versus not registered turns on the intent of what you're trying to register, to me, that seems like that's infringing somebody's free speech rights. Now, granted, nobody's telling Simon Tam he can't call his band the Slants. That's perfectly fair game, perfectly legit. The Lanham Act did not speak to that issue whatsoever. But the matter is, he is being denied certain benefits that he would otherwise get if he changed the name of the band. And one point that Simon makes, and that I think is a very good one, he says, look, if our band was all white folks, and we called ourselves the Slants, there would be no problem with that. What he says, and I've said this on the show before, is that we were being penalized for being too Asian about our Asianness, or something to that effect. Yeah. And so he's saying, that really, when we were trying to take this term, very derogatory, hurtful term, and trying to turn it around and use it as a weapon against racism, that's very powerful and meaningful to us. And to find out that we can't get that registered by the federal government, that's we find that very distasteful and unconstitutional. So, for all those reasons, I think it's a compelling case for the court to look at. I too think that this is going to ultimately find its way up to the Supreme Court, maybe in conjunction with the Redskins case. I mean, who knows? But it's a very important issue, and I totally totally understand and sympathize with the arguments about how we don't want the N-word and we don't want other terrible marks being registered. I hate it. I think it's abhorrent that anybody would want to register such terrible things. But I'm not sure what to do about that given the countervailing issues in play. So, but Professor, great article.
Thank you.
I got to thank you both too. I think you've both really nicely illustrated why this is a perfect kind of issue for the Supreme Court, and that they'll have a lot to talk about when they take this up. I had a follow-up question about your op-ed, Christine, that relates to the fact that the slants, as we've been discussing, haven't had the opportunity to register their trademark and are seeking to register it and have it hold up and that be okay. But the Redskins and other disparaging marks that are out there have. Do we care about the consistency here?
Well, there seems to be a lot of discussion about the inconsistency in this area of law, and I will not try to argue that. I will just point out that there's all kinds of inconsistency in trademark law. I mean, there's not an issue that you can raise in trademark law that doesn't have wildly inconsistent results. And the reason is because all of the issues in trademark law, unlike copyright, unlike patent, are decided in the context of a particular marketplace with a particular set of consumers and what understandings they bring and what is the surrounding information. And so you'll have different rulings on the same word. And you'll have different rulings on new marks and very, very old marks. But this is one of the points that actually Judge Moore made at the INTA conference. She said, I can distinguish the slants case as a mark that hasn't been registered, is applied for registration, from the Redskins mark, which has been, and she didn't say registered, she said used for 85 to 90 years. In fact, some of those registrations are from 1999. And in fact, the slants mark has been used. So there's no distinction between the use of the mark. They've both been in interstate commerce. They both qualify for protection. I think some people do believe it seems to be a different case when someone has had a longstanding registration. They feel like it's really an unfairness to a company that's invested in its trademark, that at any point someone could come up and challenge the mark as being scandalous or disparaging. I myself have absolutely zero sympathy for the team on that point, because one of the things that this litigation, that's by the way has been going on for over 22 years, has indicated is that Native American leaders met with the owner of the Washington Redskins in 1972, and they laid out the case as to why these marks were disparaging, why they wanted them to back away from the marks and stop using them. And the owner of the team at the time wrote the NFL commissioner saying, I met with these people. They had a very cogent argument to make. So there was certainly notice long before the case that these things were offensive, and there were all kinds of protests throughout time. I mean, if you're going to choose a racial referent as your trademark, then you ought to know that times may change. We may accept words at one point that we later find to be abhorrent, and if you're going to choose to invest in a word which has a racial meaning, then you ought to be careful.
Yep, great point. We need another MCLE passphrase for this show. I thank you so much for your wrap-ups from INTA. Let's make .sucks domain our second passphrase for folks who need such a thing.
And
let's move on.
Out?
Yeah, no, it doesn't have to
spelled out. Or
nope, you can just type a dot. That's how I put it in. .sucks domain. Let's move on to our final end of show kind of material here. We do have an animal selfie of the week for you. It's going back a little bit. This was making the rounds in 2014. I don't know why it hit my radar yet again, but I'm going to show it to you because it's pretty fun. All right. This came across my Facebook feed again, for some reason was being referenced, even though it's a couple of years old, probably because it's just so awesome. It's a white-tailed eagle taking a 111 mile per hour flight over the city of Paris. This was arranged by Freedom. It's a nonprofit organization that intends to bring white-tailed eagles back to Europe and France, where they've been extinct. And they're, at least in 2014, I hope it's still an ongoing project. I went and visited the site to see if they'd come up with their movie yet. But in 2014, they're working on a movie called Freedom, an Eagle Takes Flight that involves films taken from Eagleback. Looks like it's going to be a neat and cool documentary. I hope they get it made. It's, again, part of the fundraising to help reintroduce the white-tailed eagle to Europe. So our animal selfie of the week would be mounted on a bird this time around. And
now, do you have to register that for the drone?
That's right. If this were the United States, you probably would have to pay, what is it, a $25 fee to the FAA? Or is it, I think for a while,
it's like $5,000. It's not a huge fine.
No, there was a tiny little fee at the beginning they were offering as an introductory matter, but that's off the table now. If you haven't registered your drone with the FAA, I think you're out of luck for the good pricing. But so yay, thank you, Freedom and white-tailed eagles, for the beautiful views of Paris. And this time around, our animal selfie has no humans in the shot with the animal, but also I don't think you could say that the animal itself was implementing the selfie here. Instead, someone flicked on a camera strapped to a bird and let the bird go.
But the animal decided where to fly.
That's true.
Yeah, that's what I'm thinking. What we need to do is set up an experiment where we can give the bird like different things that he could fly to take pictures of that would give him different treats, and then let the bird choose which one he flies to. You need to have the camera on basically the entire time, though, and it probably just wouldn't work. But
yep.
One day I'll write
those
a good law professor exam question.
Variables in the legal analysis as to the copyrightability of the film. Our resource of the week goes to what we were talking about, the domains and everything that would have been talked about at INTA. Christine, you tweeted this. It's a great graphic that it's a little infographic that helps people understand who owns what domain, what domains are, what's a top-level domain, what's a subdomain, and who owns things like some of the most popular generic top-level domains, things like .sucks, things like .tv that are owned by a country. I think it's TWiL. Is that how you say the country that owns .tv? But are used for things like twit.tv and .am and .fm kind of fall into that category as well. So it's sort of a complicated web of how that all works. Very nicely explained in this infographic. Is there anything you want to add to this, Christine?
Watch this space. These issues are coming up fast and furious now. I think we have now 1,000 new top-level domains added to our existing 22. So it's quite a percent increase. We're going to see a lot of trademark disputes here.
All right, we will continue to watch. And what we'll also watch, hopefully in accordance with our tip of the week, is what sort of charger, USB charger, you are using for your devices. Over at Ars Technica, Dan Gooden wrote up a kind of false USB charger concealing a keystroke logger, warnings from the FBI about this. It's something that you would plug in and just sort of have there in your house and maybe plug various devices, your phone or what have you, into it to charge. And it's going to do that. But also, while it's doing that, it's going to be logging keystrokes, perhaps, from your wireless keyboard, which it is attempting to intercept the transmissions from. So various keyboard manufacturers, Microsoft, et cetera, are saying, well, we're trying to make sure that our technology is up to date and secure, and that this sort of exploit wouldn't be possible. That sniffing attacks like this work with any wireless device that don't use strong encryption to encrypt the data transmitted between the keyboard and the computer it's connected to. So the tip is, I'm one to pick up the $3 USB charger that you get at the gas station that's completely off-brand and made in China. Maybe those aren't such a good idea. And also pay attention to what kind of wireless keyboard you have and make sure that it's got the right kind of encryption to avoid this kind of exploit. Emory, anything to add here?
No, it's a scary, scary world out there, though.
Yes, it is. But it hasn't been scary at all here on the show today. It's just been a delight, a great discussion. I understand a lot of this stuff better than I did at the beginning of our talk today. I hope you guys do too. Had fun going through it all. Christine Farley, such a pleasure to meet you. Is there anything going on at the American University Washington College of Law that you'd like to share with us? Let us know that people might be interested in.
Always things going on. We have a really active and vibrant community around especially IP issues and information justice. I'm teaching a course on design law the week after next. And then after that, I'm going down to Cuba to teach Cuban lawyers about U.S. trademarks.
Oh, how very cool. How long are you in Cuba? Where are you staying?
I'm going to be a week and a half in Havana at the Hotel Nacional.
Oh, how fun. What a delight. Take lots of pictures.
I might find a mojito or two down there.
You might.
I might.
We
that's
wish
where they
you.
grow.
Yes. Just pluck them off the mojito tree. It should be right there for you. Have a wonderful time. And thanks so much for joining us today. It's been a pleasure.
It's been a lot of fun. And I want to thank you for doing such a careful show. Well-researched, very thoughtful commentators. So I'm very glad to be a part of it.
Thank you so much. Mike Keys, great to see you again. How's Seattle these days?
Seattle's great. I haven't been here much. I've been on the roads, so it'll be nice to be back here in the great state of Washington for at least a few days now. So great to be with all of you. Professor Farley, a real pleasure to finally meet you. I'm sorry we didn't have a chance to meet at it, but hopefully next year.
Definitely.
Right. And you can pick some coffee off the coffee trees there in Seattle for us while Christine is enjoying her mojito. And Emory and I will just continue basking in lovely Southern California, which this time of year tends to be pretty cloudy and overcast in the early part of the day. But right now it's burning off and the beach is beckoning. So Emory, I'm sorry to hear you've got a lot of summer commitments, but hopefully that's not going to interfere with your beach time too much.
Nothing I didn't sign up for. It's okay.
That's good. That's good. Great to see you again. Thanks so much, all
Thanks
of you.
for having me.
Yeah,
this was a great show. Glad to be here.
It was good fun. I'm so glad that all of you listening and watching have been able to join us. If you joined us live on Friday when we recorded this show starting at 11 o'clock Pacific time, 1800 UTC, that means you got to play along and experience some of our Skype hiccups possibly, which hopefully will not play too large a role in the official version of the show that we release on the website. But we love it when you join us live as we record. Jump into IRC with us, play along, let us know what you think, what you think we should be calling the show. Give us your thoughts on the topics we're discussing as we're discussing them. What could be better than that? Well, if you don't have time, then of course you could always go to twit.tv and the TWiL page there, and our whole archive of shows is available for you. And that's pretty fun to go through too. I enjoy going back and seeing what we were talking about a few years ago and how we're possibly still talking about the same case because cases take so long to run through the court system. Oracle versus Google is certainly an example of that kind of thing. So it's great that you could join us. We're so excited. Could not do the show without our enthusiastic viewers and listeners and contributors who are very kind about tweeting things at me and Emory and Mike. Please keep that up. Emory is Emory Roane on Twitter. Mike is J. Michael Keys. I'm D. Howell over there. Email us between the shows. We are respectively Denise, Mike, Emory at twit.tv, each one of us at those particular names. And you should hit up our Facebook and Google Plus pages too if you want to check in, see what we're planning for the next show. Oftentimes I'll post our discussion points over there, which for every single one of these shows, if you go to tagpacker.com/user/thisweekinlaw, find our episode number that you're interested in, you'll see all the links that we have reviewed in getting ready for the show and either talked about or at least considered talking about on that particular episode. So we're thrilled that you've been able to join us. We will be back next week. Until then, take care.